I call the honourable member Chris Hipkins.
Thank you very much, Mr Speaker. Mr Speaker, I find myself in the very uncomfortable position of rising to defend Judith Collins. I feel unclean. Mr Speaker, I actually support the bill. I've now had the opportunity to read it thanks to the waffle coming from certain other members in the House. I've had the opportunity to sit down and go through it. And I do believe that this is a case where urgency is warranted. Now, I'm very critical of the government's overuse of urgency, and I think that particularly pushing bills through all stages under urgency, and a lot of cases that the government have done it, have been totally unnecessary. But in this case, I think there is actually a legitimate reason to do so. And I think we want to be really clear about what we're doing here. What we're doing is by fixing this mistake under urgency, passing the bill through all of its stages, is retaining the status quo. So we're not actually changing anything, we're actually retaining the status quo. The change was made by mistake, and we're fixing the mistake. Now, Parliament didn't get all of the advice on the pros and cons and everything of making the mistake in the first place. What we're doing is fixing it and just retaining the status quo. Now, if members have a legitimate concern about the status quo, there's other avenues to debate that. There's other ways that they can raise those concerns. But actually, retaining the status quo is the responsible position for Parliament to take in this instance, because this change was never intended to have been made. Now, the question, of course, is why? So we're fixing a mistake. Why do it urgently? Well, the reason for urgency and the reason for doing it all at once and without a huge amount of publicity and notice prior to that is because we don't want to see a whole lot of young offenders who have been convicted getting off those convictions because the information that the police had held that allowed them to identify them in the first place was something that technically under this mistake in the law they weren't allowed to hold. And I want to talk particularly about what this might mean in the context of something that I hope people will be able to understand. And in doing so, I hope that members will acknowledge that I've only had half an hour to actually look at the bill and the notes. And if I make a mistake in that, the Minister can correct me in her next speech. But we've had a problem with these young offenders in Upper Hutt. Etching shop windows, and they have caused thousands and thousands and thousands of dollars worth of damage etching these shop windows on the main street of Upper Hutt. Now, as I read it, if those young people, the police identified them, if those young people had previously been found guilty of something by the youth court, anything other than that last provision, which was O, I think, other than clause O, but and they hadn't been sent to the district court for sentencing because it had been something that the youth court had dealt with itself, the police would then have no longer been able to hold the photographs and fingerprints that they would have otherwise held. If those young people then reoffended, and they were caught reoffending because when they etched the windows on Main Street in Upper Hutt, they'd left fingerprints behind, the police had used those fingerprints to identify them, had then convicted them, under this law, technically that's open to appeal. And I'm looking for the Minister, I'm hoping that she'll correct me if I'm wrong, but technically that could be appealed, and those young people, having done thousands of dollars of damage, could actually be let off. I think that everybody who had been the victims of those thousands of dollars of damage to their shop front windows would be outraged at the thought that they could get off on a technicality because of a mistake that this Parliament had made that was totally inadvertent, totally unknown, and could not have been foreseen. And so I think that what we're doing here is the responsible thing, which is making sure that those convictions are allowed to stand. So looking under, I think it's also important to remember why we send young people to the youth court. The youth court is established to protect young people so that they don't have to go through the district court process, except if, under very limited range of circumstances. What this mistake has effectively done is is diminished the powers of the youth court in a way that was never intended. And actually, I'm a defender of the youth court. I think it's important that we have a youth court, that we don't put young, vulnerable kids in the district court system unnecessarily. But in doing so, we have to make sure that the powers of the youth court are protected. And what this inadvertent mistake has done is it has severely diminished the powers of the youth court in a way that I'm sure Parliament never intended. So what we're doing in supporting this legislation is moving back to a position of the status quo. Now, that doesn't mean that some of the concerns raised by Keith Locke and Rahui Katane aren't worthy of debate. I'm sure that they are. But in retaining the status quo, what we do is we defer those concerns for another day, and we allow another opportunity. I hope there'll be another opportunity for them to have their arguments put forward on those in due course. So looking at the Youth Court, the provisions of the Child, Youth and Family Act, where the Youth Court would be dealing with some of these young offenders, they could be imposing a fine, for example, at the Youth Court that would otherwise be imposed by the District Court. So the outcome is effectively the same as it would have been in the District Court, but it's being made by the Youth Court instead. And the police therefore would have to technically, under this mistake that's made, destroy all of the fingerprints and photographs that they had held of those young people, but potentially preventing them from identifying reoffending by those young people. It actually could potentially, prevent the police doing the good work that they do in preventing youth reoffending. And I think that's ultimately where we've got to get to. We've got to say, well, we don't want young people to go on and keep reoffending and end up in the district court system when they're older. We want to actually give the youth court and the police the ability to deal with these young offenders and get them straightened out and get them back on the straight and narrow, so that they're not getting into trouble for longer. And I'm concerned that this inadvertent mistake weakens the police's ability to do that, and that's one of the reasons why we're going to be supporting it. So the youth court could have imposed a fine. The youth court could also make an order for the young person, or in the case of a young person who's under the age of 16 years, for any parent or guardian of the young person to pay a sum towards the cost of the prosecution under the mistake that's been made. That would also result in all of the fingerprints and photographs being destroyed. They could order the young person, they basically order the young person to pay the person who had suffered emotional harm or loss, or the damage to the property, or damage to property sum that it thinks fit by way of reparation. So basically it provides the court the opportunity to say, if a young person has done something wrong, they can pay reparation to the victim, or their guardian could pay reparation to the victim. In those cases, so basically they've been found guilty. They've done it. The youth court has heard the evidence and determined that they've done it. And in a district court, where they had an adult being convicted, there would be no issue. The police would be able to retain their photographs and fingerprints, but because it's a young person being dealt with in a separate court set up to protect them, we actually give the police lesser rights or lesser ability to retain the evidence that they'd previously been able to gather, and I think that just doesn't seem right. And I think one of the most important things about the youth court is that we set it up to protect young people, and we shouldn't diminish its powers, because actually that undermines the legitimacy of the youth court. So I guess overall, as we go through the debate, I'll be interested to hear further argument on it. But it seems to me that what we're doing is we're correcting an anomaly. I do want to respond just briefly to the comments by Shane Arden and reassure him that any evidence the police collected when he drove his tractor up the front steps of Parliament would not be covered by this legislation, because he's long since ceased to be deemed to be a young person. So he's fine. He doesn't need to worry about this at all. He's childish, but technically under the law, he's got nothing to worry about. All of the evidence the police collected when they were investigating that matter would still be able to keep that. So, Mr. Speaker, the Labour Party is supporting this legislation because we think legitimacy is urgent in this case, and it does retain the status quo.
Mr. Speaker,
I call the honourable member